Okay, I got the thumbs up. All right, well, there's breaking news out of federal court in Texas. The Corporate Transparency Act, which is the law that requires you to file a federal beneficial ownership information report to the federal government, has been ruled unconstitutional. This is big for you if you own an LLC or corporation. This was a requirement. We filed thousands of these for my clients in our law firm this past year, and this law has just been ruled unconstitutional. That is great news for business owners because you do not have to file this. If you're one of those people that was waiting and late, no requirement to file it right now. Now, I want to get into this case because this is really important. You understand the actual court's ruling on this. You got to get past the headlines on this and the influencers dropping stuff on this that don't know what the hell they're talking about. Okay. I'm a lawyer and I've represented clients setting up tens of thousands of entities across the country. I know what matters and what you need to know. I'm going to give you a course of action you should be taking because of this case. Now, the case is called Texas Top Cop Shop versus Garland. I've actually read the opinion, okay, not just the headlines on this. Now, here's the critical thing in this case. This law has already been ruled unconstitutional in Alabama. But what happened in that case is the Alabama judge said this only applies to the plaintiffs in the case. But this new ruling out of Texas is saying the contrary. It's saying it's unconstitutional, but it is doing what is called a facial challenge and saying it is constitutional for everyone. Nobody has to file this anymore. If you are, quote unquote, a reporting company, an LLC or corporation that would have been subject to this law, the federal court in Texas has said this is unconstitutional, whether you're in Texas, in California, in Arizona, in Rhode Island. I don't care what state you're in. This law does not apply to you anymore. That is huge. Okay, this is a huge breakthrough. And this is good news, I think, for small business owners. Now, we've been helping clients file and comply with this. We set up hundreds of LLCs every month, and we're having to file this because you have to. Okay, there's federal penalties, jail time if you didn't do this. No longer that is the case. Now, I want to get into what's going to happen next, but I want to go over a couple things in the case itself that I think is critical. But I'm going to go over what you should be doing. Should you file this? What is FinCen saying? We got to come to that. This is the federal government agency that's held to enforce it. And I want to talk about the politics on what's going to happen on this because we've got Joe Biden still in office right now, who's a fan of this law. Trump has not come out one way or the other on it. I want to break down the politics on this. He actually vetoed the original bill that had this law in it, but he did it for other reasons. So I want to come back to this because the politics and how the appeals are going to go in the next year is going to be critical because it's possible this law could come back. I don't think that's the case, but I want to give you the analysis so you know what to do. All right. Now, the court's ruling, again, applied to everyone that would be subject to this law. This is not just people in Texas, not just the plaintiffs in this case. Nobody has to file this requirement and do the BOI filing anymore. The second thing that's important in this case is there's going to be appeal. Now, the federal government is the other party in this case. The Attorney General and the Secretary of Treasury are the defendants in this case, and they're the ones that are going to have an appeal right. And under a current Department of Justice that has been enforcing this, and a Treasury Department that's been enforcing this, and a President Biden that's been a fan of this law, is likely that this is going to be appealed. And this will get appealed to what is called the Fifth Circuit Court of Appeals before it goes to the U.S. Supreme Court. Now, do you think the Fifth Circuit Court of Appeals is going to uphold this? I don't know. I don't even know that we're going to get there because President Trump's going to be inaugurated here in January. We're going to have a new Attorney General, a new Secretary of the Treasury, and you're going to have a new sheriff in town, so to speak, that's probably going to say, I don't think we should go and enforce this. Is all of the government regulation, we've got the Department of Governmental Efficiency coming around the corner. In the court's opinion themselves, they've estimated hundreds of billions in compliance costs for small business owners to comply with this. And we've got a Texas federal judge already saying it is unconstitutional. So I think it's likely the politics on this is going to be a Trump Department of Justice and Treasury Department is going to say, let's pull the appeal. Even if the Biden department does appeal it, they're likely going to pull the appeal, is my guess here. And I think this Texas federal court ruling is going to become law of the land. Now, that part is speculation. So I can't tell you where this is going to land forever, but we know right now you do not have a legal requirement to file a BOI for your LLC or corporation. Now, if you've already filed it, don't worry about it, okay? That's already filed. It's private with the federal government. You already did what you're supposed to. Good for you. I filed these on my own entities already because I wanted to get ahead of it and I didn't want to worry about penalties. Okay. So now, if you're one of those people that we're delaying or you're setting up a new entity right now, even in our law firm right now, what we're doing, and we just communicated this to our team. I mean, this case is brand new today, right? This ruling was just filed last night and official today. So everybody's figuring out what to do with this. But our recommendation to our clients is don't file the BOI. You don't have to. This federal ruling applies to everyone, and so there's no longer a federal legal requirement to file it. Now, FinCen has not responded yet. They just got the order yesterday too. Okay, so I went to FinCen this morning. They have no response yet on what they're doing. They're still accepting BOI reports, and this is the federal government. Let's be honest; it might take a while to figure out how to respond, and there's got to be a lot of people that chime in and all this. But so we're going to be waiting to see what FinCen said. Are they going to enforce it? Are they going to wait for the court to figure it out? Are they going to kind of wait and see, let the Trump administration deal with it? Who knows? But even if they came out and said, hey, you still got to file. We think this one judge in Texas got it wrong, and we're going to appeal. Even if they do that tomorrow, next week, whatever, they still got to go through the appeals process and win. They got to go win in court. They already lost. Okay. So this district court in Texas has set the law of the land for now, and they're going to have to go appeal it and win in the appeals court, which again, you're going to have the Trump administration in office by that time. All right. Now I want to see if there's any questions we have. Anyone live? If there's any questions, I'll hit those. Looks like no questions pending right now. All right. Now I want to get into some facts of the case that I think is helpful to know, and it's pretty interesting. There was actually 6 plaintiffs in the case. There was a Texas Top Cop Shop. That's the named plaintiff. This was a small business in Texas. They only did business in Texas, and they had 4 employees. They provided equipment to first responders. And the people who brought this case were very smart in how they brought the plaintiffs to the case. Texas only plaintiff, didn't do business outside the state of Texas, didn't have interstate commerce. Okay. They only conducted business in the state of Texas. There are some other businesses, an IT business that did business in Illinois and Texas. There was a Wyoming dairy farm. There was the Libertarian Party of Mississippi. And then there was the National Federation of Independent Businesses that was kind of, it's a big association for independent businesses across the U.S. Big advocate for small business and individual ownership of businesses. We love NFIB, but they came out against this law from the very beginning, and they were part of the ones leading the charge to get this ruled unconstitutional. Now, but NFIB was bringing the case on behalf of their constituent members. They themselves were a nonprofit, not a reporting company under the laws, but they brought it on behalf of the plaintiffs. So these are the people behind the case that went and won it for you. So we should say thanks, first of all, to all of those people that came and brought the case, did the hard work, and got the big win in federal court. Now, this is a nationwide injunction, okay? And the law that was at issue here was, does the federal government have authority to regulate what information is filed for an entity? Because entities are created at the state level. You set up a corporation or an LLC, you set it up with the state you're doing business in, right? And so that is a state regulatory requirement. And so the question that was raised from this is a constitutional question of, does the federal government have any powers to regulate this and to request this? And this comes down to what's called the Commerce Clause. And the federal government was saying, no, we have power to regulate this under the Commerce Clause. Okay, and the Commerce Clause is something in the U.S. Constitution that says the federal government has the ability to regulate commerce between nations and between states, okay, and businesses within states. And so that was their calling card, so to speak. That was what they were hanging their hat on, to have the authority to regulate and require this for entities that are set up at the state level and are state regulated and state adopted LLCs or corporations. So now they lost that argument. Okay, that's what the whole case was about. This 80-page ruling from the federal district court in Texas from Judge Mazant is all about the Commerce Clause. And they talk about something called the Necessary and Proper Clause, but that was an easy, more straight analysis. This is all about the Commerce Clause, and that the federal government does not have authority to regulate that. So we will see what happens here. The other thing I think is important to know on this was what happened in the policy making when this law was first enacted. So back in 2020, when this law was first enacted, called the Corporate Transparency Act, it was part of the National Defense Authorization Act. There was like 10 other bills that were part of this law that got signed into law. Now, Congress passed this back in 2020, and this is the Corporate Transparency Act where this BOI rule came from. Within that within the law that Congress passed was National Defense Authorization Act and a whole bunch of other stuff. Well, it went to Trump's desk in 2020 before he left office, and he vetoed it. Okay. Now, when he vetoed it, he said actually during the veto that he vetoed it because of the government spending and the defense spending in there. He didn't highlight any objection to Corporate Transparency Act. So we don't actually know where Trump stands on this right now and what the new administration is going to do on this. But that was an interesting little, how the law came about. Now, what happened though is Joe Biden got inaugurated in January and then he signed it into law. Okay. And so then it became law of the land after President Biden came into office. So we'll see what happens right now from the politics of this. We're going to be waiting and see what FinCen sends. So make sure you're subscribed to my channel. I'm giving updates on what's happening here, whether you need to comply or not. Is FinCen, going to still try and enforce this or not? And then also, what is the new administration's position on it? We'll see. There's likely going to be some commentary on this from President-elect Trump or his administration about their take on this, because this is a big issue for small business owners. And I said this for a year ago when this was first a requirement that you had to file, which was, this is the biggest change for LLCs and corporations since I've been a lawyer. I've been a lawyer 20 years now. This is my 20th year as a lawyer. This is the biggest change and legal requirement for LLCs and corporations, this new federal filing requirement. You never had to file anything to the federal government. You just had to go get your tax ID to file your company's tax return. That's all you had to do. Everything else was done at the state level because the state has the power to regulate and adopt and authorize LLCs or corporations. So this is a huge change. It is now unconstitutional. Make sure you're subscribed to stay tuned for it. Make sure you're also subscribed to our law firm. If you're a client of our law firm, you can go to KQS Lawyers. If you need company compliance services, our business services company, Main Street Business Services, you can get to mainstreetbusiness.com. We're doing BOI filings there, but we also handle all your stuff with the state to do your state renewal, your annual minutes, and make sure your entities are up to date and compliant with the states. All right, well, that's it for now. I'm going to be back with